Yeah, I never started. You have to get the panels page.
Yes. Yeah. No, I mean, I think I'm sort of 88 taxpayer, 20 HMRC.
I can imagine it's quite useful.
Go from both sides.
Well,
Did you do much advisor work or litigation?
probably about 50. Well, more litigation than advisory these days. It takes so much time, doesn't it? Yeah, I do keep doing a good chunk. Keeps your knowledge up to date. Otherwise, you'll learn a lot about a few very key areas. I'm sure no one's ever thought about regulation through as much as we have.
No. No one ever will again.
Exactly, they'll be told the answer.
Court rise.
Sorry to have kept you waiting.
My lords, my lady, I'd just completed my explanation of the theory of how matters could proceed if, in the course of an appeal before the tribunal, for example, against a Regulation 9 refusal, HMRC issued a Regulation 13 determination either in bad faith or to protect a time limit. I mentioned that there's the possibility of raising a JR proceedings, then the issue, because the jurisdiction is given to the tribunal to determine the issue, the tribunal determines that and the JR follows. The practical reality, though, is that if HMRC were issuing, for example, a determination to protect a time limit, I understand my instruction of the practice is that an appeal against that would be invited.
Speak up a little.
Sorry, sorry, Lord. An appeal against that would be invited, and that would, of course, open up any power that was needed to set aside the determination if the tribunal thereafter found that the refusal was wrong, the Regulation 9 refusal was wrong. In other words, an addressee is protected in theory by the possibility of judicial review, but in practice, HMRC would not insist on that and have a far less formal, less costly mechanism for achieving the same end. And so, when it comes then to section 3 of my supplementary...
Can I just come back to North Point?
Yes.
Can I understand what the Review's position is, because unless I may not have spent long enough in North Point to understand it, but in that case, I think as you said earlier, there was both a determination and a refusal under Regulation 9.
Yes, lady.
What the taxpayer was trying to do, what the contractor was trying to do, was say that there shouldn't have been a refusal under Regulation 9.
Yes.
And the tribunal said we haven't got jurisdiction to consider that. How does that fit in with what you've just been saying?
In my submission, it fits in because the facts in North Point were that the Regulation 13 determination that was made at the same time as the Regulation 19 refusal. So one can see that in if one.
Yes, I've got that. Yeah, I can see, and you said that earlier. That's
yes. Yes. So jurisdiction, in my submission, is tested at the time appeal proceedings start, and jurisdiction couldn't be ousted by a subsequent Regulation 13 determination. And that's because, well, the first point is that what the tribunal is deciding, the question the tribunal is deciding is whether the Regulation 9 request should not have been refused. In my submission, so far as North Point says anything covering a scenario in which Regulation 13 determination is made after proceedings have started, it is obiter.
Well, it doesn't really matter. It's obiter. It's not binding on us. But the question is it right?
Yes, and in my submission, it's wrong because there is no warrant for allowing a Regulation 13 determination, at least in that context, of being made after proceedings have started, to oust the tribunal's jurisdiction.
So does it follow that Mr. Justice Fordham was wrong to approve it?
Well, I'm not sure Justice Fordham quite went so far as to approve it in the way my learned friend said. So if one looks at North Point,
well, he sets out the facts of North Point in paragraph 21, and he seems to endorse North Point at paragraph 53.
Yes, let me just find that. Well, yeah, so what he said in paragraph 53 is about halfway down. The FTT was correct in North Point that public law principles enforced by judicial review are available to address questions of abuse. And then he says, he records that he's wondered actually about whether North Point situation, where a carefulness appeal against a refusal is extinguished by a later liability determination, is answered by the FTT being able to give a directed direction taking effect from the date of the refusal. So in fact, and that's at least similar in concept to the position I'm putting forward here. So what Mr. Justice Fordham is saying there is that he endorses North Point as far as the proposition is that Regulation 13 determinations as an act by a public body are susceptible to the usual public law grounds of challenge. No one disagrees with that, I don't think. We may have a disagreement about the extent of them, what they may be, but that's common ground. And then he says that he's actually not so sure about the idea that jurisdiction in an ongoing appeal, in an ongoing appeal, is ousted by Regulation 13 determination. And he thinks that the answer to that is that actually the way it works is that, as I've been seeking to submit, the tribunal's decision looks back to the date of the refusal and says, at that date, the refusal should not have been given. There was an obligation on HMRC to make a Regulation 9 direction. And that part of the tribunal's function cannot be usurped, because the only act of the tribunal to which any possible objection is raised is the tribunal making a direction to HMRC to make a Regulation 9 direction.
Well, that's contrary to what the judge thought was your position.
Well, we didn't argue about that at the time. Now my friend has raised this new point about Regulation 13 determinations made to protect a time limit, which certainly in my recollection wasn't raised at first instance, but it's raised now. And had there been more focus on what happens when a Regulation 13 determination is made in the course of proceedings, that I might well have argued that in any event. It wasn't argued, but it's not the case that Mr. Justice Fordham adopted or approved a position that a Regulation 13 determination made in the course of an ongoing appeal ousts the tribunal's existing jurisdiction to determine that appeal.
I appreciate your responding to the submissions made, and as you mentioned earlier, the facts of North Point are different. You have the refusal and the determination essentially at the same time.
Yes.
Do you say, does the revenue say that North Point is right in that scenario? Or is that something you're unable to comment on?
Well, I suppose my submission is that there's always going to be a chronology. One is going to be made before the other. And so if the Regulation 9 direction is made, if that's granted, then of course there's an appeal against determination on the ground it shouldn't have been given. If Regulation 9 is refused, then
well, maybe
yes,
the making of the Reg 13 determination rather implies that there has been a prior refusal. The Reg 9 direction.
Yes, if there's been a request or a material put forward.
But you're still not dealing with a situation where there are extant appeal proceedings, which has been the focus of your submissions earlier.
Yes. If there were first a Regulation 9 refusal, followed by a Regulation 13 determination, then I think the logic of my position ends up being that the tribunal can still hear an appeal because it is focusing on the time of the Regulation 9 refusal.
Sorry, I made it that way. There's a Reg 9 refusal followed by
a Regulation 13 determination.
Yeah.
Then the tribunal still has jurisdiction in a Reg 9 appeal because the appeal is focused on the date of the Reg 9 refusal.
And in that situation, I understand you to say that it would be accepted that that the taxpayer would also appeal against the Regulation 13 determination. Indeed, the taxpayer needs to in this scenario, otherwise it's going to become final. And
Yes.
that would, the grounds of that appeal, assuming nothing else is in issue, would have to engage the fact that there's a dispute going on about Regulation 9.
Well, yes. If that appeal were to go to the tribunal, but the reality is that the appeal has to be made to an officer of HMRC in the first place.
Sorry, the appeal has to be what in the first place?
And made to an officer of HMRC.
Yes, so what?
That appeal need not be heard in the tribunal. It would simply be kept in abeyance.
But it could go ultimately to the tribunal, unless I'm not understanding your point.
Well, the process for going to the tribunal is that as a generality, the thing about the Tax Management Act 1970, the taxpayer has to notify an appeal to the HMRC officer.
Yeah.
Then the HMRC officer, at some point, but without any time limit, has to give a view of the matter. Then the view of the matter offers a review, or the taxpayer can go to the tribunal. So at that stage, the taxpayer chooses within a period to do.
That's all just detail, isn't it? How does that affect the point of principle we're considering?
The objection that's been made to me, as I understand it, is a point of principle. It depends actually on practical problems that the interpretation be put forward gives rise to. Now, my submission is that those practical problems don't really exist, because in practice there are mechanisms. The formal one of judicial review, or the practical one of an appeal to HMRC, which ensure that the problems identified.
Leave out judicial review for the moment. Yeah, but we're looking at the scenario where HMRC do not agree with the officer considering the appeal, doesn't give in.
Yes, well, and I suppose the ground of appeal against the subsequent Regulation 13 determination would, could be simply that the Regulation 9 refusal was wrong in law, I suppose.
Well, it would have to be, wouldn't it? That is the substantive point. That's what my lady was putting there, unless I've misunderstood it.
Yes.
I mean, there might be some other ground, but imagine a clean case where that is the only... The ground of appeal in any ultimate appeal to the FTT, if the intermediate procedures you mentioned don't get you home, don't get the taxpayer home, would be that the Regulation 9 refusal was wrong.
Yes.
Refusal to make
Yes.
a Regulation 9. Yes. So,
Yes.
so you're agreeing with my lady.
Yes. Yes. But of course, that's available only in the scenario where the Regulation 9 refusal has preceded the Regulation 13 determination.
Well, that's how the judge understood North Point. If you look at paragraph 21, he says that the claims for non-liability directions, that's in Regulation 9.5 application, were refused on the 28th of February 2017 and the 5th of April 2017. They appealed against those refusals on the 3rd of May 2017, and the Regulation 13 determinations were then made on the 14th of August 2017, that is to say after both the refusals and the appeal. And yet the FTT said, going further down, on the correct interpretation of Lin 2 of the interrelationship provisions, the liability determinations, that is the Regulation 13 determinations of the 14th of August 2017, i.e. after the appeal, meant that it was no longer open to the FTT to consider the appeals against the refusal of the direction under Regulation 9. That's what the FTT decided. Now, 53, the judge doesn't say that any of that is wrong. Do you say it's right?
Well, if I can take your lordship to North Point, which is at tab 14.
I mean, are you saying the judge misunderstood North Point?
Well, I'm not sure the judge quite got the chronology correct, but if I can take your lordship to North Point, tab 14, page 454 of the bundle, number page 454. And starting at paragraph, subparagraph 15.
Yeah. So that's the refusal of the 9-5 direction.
Yes, that's the decision that they weren't satisfied that the criteria were met. They came to the view. And then the same day, taxpayers' accountant sent further information to HMRC. And the decision refusing relief wasn't sent to the appellants until 5th April 2017, when the determinations were sent to the appellants. So the
so that's the Regulation 13.
Yes, that's right.
I follow.
That's right.
So the judge has misunderstood the chronology, you say?
Yes, and I think the August date is the 14th of August.
The 14th of August is mentioned in subparagraph 21.
Yes, and in North Point it's mentioned in paragraph 1 as being the date on which determinations were issued. But that contradicts the chronology I just looked at.
Right.
And what?
So North Point understood, the tribunal in North Point understood that the determinations were issued on the 14th of August 2017. That's what they thought, at any rate. And that is after the appeal. And they say, at paragraph 22, I think it is, no, 20.
Mm-hmm.
Once an amount of the excess has been included in the determination, that is Regulation 13, it is no longer open to either HMRC or the tribunal to make a direction under Regulation 9.5. That's what they say. And that seems to be on the understanding that the appeal is against a determination on the 14th of August, and there had been a preceding appeal against a refusal under Regulation 9.
Yes, but if one looks, my lord, at paragraph on page 454, subparagraph 21, the tribunal there is at least clear that what happened on the 14th of August was the review conclusion letter. The review conclusion letter.
Yes, but I think technically the appeal may be against that final decision.
Yes. So
I'm not sure there is the misunderstanding that is being suggested.
well,
At least
the chronology is that Regulation 9 was decided not to be granted. Then that decision was communicated to the addressee at the same time as the Reg 13 determination was communicated. Then there was an appeal notified to HMRC. then there was a review of both, and then there was an appeal notified to the tribunal. So that's at least the chronology in what actually happened in North Point, and the chronology on which the first-tier tribunal in North Point was making its decision. So, in any event, the facts were that the Regulation 13 determination had been made and issued before an appeal was notified to HMRC, and likewise before an appeal was notified to the tribunal.
So, but the upshot is the tribunal said we have no jurisdiction to consider the Regulation 9.5 appeal. It's been taken away by Regulation 13.
Yes, that's what the tribunal. That's what the tribunal has concluded. And my submission that certainly is not the case once an appeal is on foot within the tribunal, because the tribunal's jurisdiction can't be ousted, in my submission, by a subsequent Regulation 13 determination.
And you've got how long? 30 days, is it, to appeal the refusal?
Yes.
So if HMRC issues its Regulation 13 determination within the 30 days, that precludes an appeal.
Isn't it in practice longer because of the view of the matter and because the point is that the appeal first gets notified to HMRC, and I think you're meant to make a distinction between notifying the appeal to HMRC and to the tribunal, which might happen a long time down the road, given probably look at the facts of this case as an illustration. You go back to the revenue first, as you've explained, they issue a view of the matter. In many cases, there may then be a formal review. All of that can take some time.
Yes, yes.
Which time limits might be cropping up.
In an extreme scenario, yes, time limits might be clocking up, but the time limit of 4 years from the end of the tax year to make a Regulation 13 determination, 4 years from the end of the tax year in which the liability to make a payment or to make a deduction passed on to HMRC arises, in my submission at least makes it very unlikely that within that period between a Regulation 9 refusal and notifying appeal to the tribunal, the time limit would arise. In any event, it may well be the case that the tribunal would retain jurisdiction, at least to make the finding that the Regulation 9 direction should have been made as per the task conferred upon the tribunal by Regulation 9 itself. Let me just get the word again. That appears that the refusal notice should not have been issued. In other words, the relief should have been granted.
So you're saying this may well have been the case. I thought your submission was that it was the case.
Sorry, that
you said this. It may well be the case that the tribunal retained jurisdiction in the scenario which you're considering. I was just querying why you said may well, why you weren't saying would. I mean, you must have a position on whether it would or it wouldn't.
Sorry. In the scenario where appeal has been notified to the tribunal, and there is thereafter a Regulation 13 determination, yes, the tribunal would retain jurisdiction.
Yes, I see.
Sorry, my lady was asking about.
May well.
Yeah, my lady was asking about the scenario where a Regulation 13 determination is issued before an appeal is notified to the tribunal.
What are you saying about that?
Well, that's where I'm saying it may well retain.
Or may well, depending on what.
Well, I suppose the correct interpretation of these provisions, apart from anything else.
Well, what you said the correct interpretation of these provisions is, that's what I'm trying to get at.
Well,
oh, you mean the actual provisions in front of us? The actual, depending on what...
I certainly cannot see any problem with the proposition. The tribunal would still retain jurisdiction to determine the question which Regulation 9 allocates to it, of whether the refusal notice should not have been issued.
Can I just pause there and look at 9.9, please? Because I understand understand that's the substantive question it has to consider, but its only real power under 99 is it can only produce a decision that has an operative effect by deciding to direct an officer of HMRC to make a direction. That's its function under 99. So I think you're postulating a situation where the FTT says, well, we can sort of say that the precondition under 99 is satisfied, but we're not in a position to go on and actually direct HMRC at this stage because there's an outstanding 13 determination. Or we can direct them, but they can't do it because it's unlawful.
Yes, although in my submission, I say that the tribunal's decision is directed back to the time of the refusal. I dare say that in practice, as we discussed a few minutes ago, the Regulation 13 determination would also be appealed by the addressee on the basis that the Regulation 9 relief should have been granted, and the tribunal can deal with those at one and the same time. And what makes that scenario different from the present case is that there's a time preceding the making of a Regulation 13 determination when a Regulation 9 direction was required to be made and was not. Here, in our case, there was no time preceding the Regulation 13 determinations at which Regulation 9 relief was required to be granted. There was no request under Condition B. And there was no material put forward in relation to Condition A. And until after the determinations had been issued. So, in my submission, it is an acceptable reading of Regulation 13.3 to allow that to cover the scenario where Regulation 9 direction is refused, is not given, but the tribunal subsequently decides it should have been given at that date. But it's not an acceptable reading, as my other friend submits it is, to go further and deprive Regulation 13.3 of, in my submission, its intended finality on Regulation 9 issues where those issues have not been raised prior to the section Regulation 13 determination. One can see a justification in policy for that if no Regulation 9 issues are raised, there's a degree to which one can say HMRC are entitled to believe that there is the issuing a Regulation 13 determination gives finality. But if Regulation 9 issues have been raised to an extent that relief should be granted, then HMRC's erroneous belief that the conditions are not met shouldn't get HMRC the finality of those Regulation 9 issues being cast aside. So HMRC gets finality if there's no Regulation 9 issues raised. It doesn't get finality if Regulation 9 issues are raised. In my submission, that's a reasonable reading and a reasonable policy approach. Have regard to the purpose of the provision, which, as I've said, is finality, in my submission. Right, I think that concludes my chapter 3, and as probably what are a diminishing number of points to make in response to my friend's skeleton argument.
Yes, there's a lot of the ground's already been covered.
Indeed, exactly, exactly. So in that skeleton argument, points 1 and 2 are about the ordinary meaning of the words and the distinction between the wording in the first and second halves of Regulation 13.3. I think I said all I want to say on that, unless there are any further questions about that. The directions don't apply, is what is said to amounts in a Regulation 13 determination. In my submission, that's perfectly capable of meaning that you can't make directions for a regulation, for an amount that's in a Regulation 13 determination. And the distinction is explicable by the different natures of the Reg 9 and Reg 13 decisions. Point number 3, my friend relies on is the fact that the two parts of Regulation 13.3 are not symmetrical.
You've covered that already, I think.
I've covered that more or less already. My point is finality in relation to Regulation 9 issues. Another point, of course, is that this sort of hibernating effect, outside Regulation 9 issues, it doesn't matter. Because if Regulation 13 determination is appealed on grounds other than Regulation 9, and the appeal succeeds, then there is no equivalent to an assessment on which HMRC can collect money. Let's suppose the appeal against the determination is on the grounds it's out of time. The appeal succeeds, the determination falls away. HMRC can't go and make another determination because it, a fortiori, will be out of time. And so you don't actually need a Regulation 9 direction for that stage, for the protection of the addressee. So this idea of a hibernating effect beyond what's the Regulation 9 issues is a will-o'-the-wisp, I would say. Because no direction is needed where there is no assessment on the basis of which HMRC can collect any amount. Point 4 is the principle of access to justice. And that's broadly about on the one hand, the possibility of thwarting appeal by issuing a Regulation 13 determination after it's on foot. I've made my submissions about that. There's issues about the costs of a judicial review. I don't think I want to say anything more about that. Yes, a judicial review is more expensive to start. In reality, not a significant amount of cost in my submission would be incurred because of the way the theory of it works. If that were what a recipient were required to do, the context of the present case is very different from Unison, because Unison was about secondary legislation charging fees that blocked access to an external system of appeals. Two points in response to that. First, the conclusion that the fees blocked access was based on extensive evidence about the types of individuals who took cases to the Employment Tribunal, their means as regards the affordability of the fees, the amounts that were recovered in cases before the Employment Tribunal, whether it was worth it having regard, even if an applicant won, having regard to the fees charged plus cost of enforcement, and empirical evidence about a significant reduction in claims following the introduction of the fees regime. So there, significant evidence showed that the fees had an effect. Here, whilst I accept the point that some contractors may not be the £3 million spenders that the legislation envisages for at least a number of terms, most of the categories of people involved, one cannot simply say that the cost for a judicial review somehow is a serious access to justice issue, justifying the conclusion that the approach being put forward by HMRC can't be right. Second, of course, as mentioned at the start, the Regulation 9 and Regulation 13 are all part...
Just pausing a moment. The access to justice argument is being used in support of a particular interpretation of the current regulations. The evidence in Unison was deployed in support of an application to quash the order raising the fees. Yes. So of course you would have needed evidence for that. But, and Mr. Firth of course accepts it's not on the same scale as Unison. But why is he not entitled to rely on the principle to inform the interpretation of the regulations without all the statistics and evidence that was before the court in Unison, where it was a direct attack on the instrument which increased the fees?
Yeah, so the principle exists, certainly.
Yeah.
One can make the point that if someone has to raise a judicial review alongside an appeal to the first tier tribunal, there's a cost in that. My submission really is that whilst the point is available to be taken, it doesn't carry the weight that my friend says it does. That's all.
So it goes to weight?
Yes, yes. Sorry, my lord, I should have been clear about that. Second point is that Regulation 9 and Regulation 13 are all part of the same regulations by HMRC. HMRC not taking the hard-nosed approach that you've failed to make deductions, contractor, you still got to pay us. Tough luck, that's the end of it. The regulations grant the possibility of relief. And the question really is just how big a possibility is that? Is there some minimum amount of possibility for relief that must have been granted in the regulations and that the way they've been drafted fall short of, or they need to be interpreted so as to allow that minimum possibility to be achieved? So it's not like the fees regulation, which blocked access to some existing other jurisdiction that was provided for in primary legislation. It may be that the regulations in our case don't give as much possibility for relief as contractors might like. But it's not comparable to a case where, for example, court fees are so high that no one has access to a court anymore. And perhaps the final point on this, the least intrusive interpretation, which is paragraph 34.4, is where my learned friend suggests the High Court made no attempt to identify it. Well, my submission, that's the interpretation I've been putting forward. Which is that if Regulation 9 issues are raised, and the tribunal still has jurisdiction to determine an appeal against refusal, but if the Regulation 13 determination comes first and Regulation 9 issues are not raised until after that, which is the present case, then it is simply too late.
Going back to Northpoint, I think on this revised position, you would not be supporting the result in
Northpoint. I think that's correct, my lady. I think that must be correct. Perhaps a minor point in point 4, I can't remember where it is. There's a criticism that the High Court failed to consider the issue about assessment or determinations made to protect time limits. I don't think one can say the High Court failed to consider that. It wasn't put to the High Court. But that's just a very minor point. Nothing turns on that. Point 5, public law principles don't address the restriction on the right of access. I don't think I've got any more to say about that, unless any more questions about that. point 6 about the power of withdrawal. We discussed that at the start of my submissions. Point 7, there must be a right of a...
You neither confirm or deny.
Yes, indeed. Point 7, there must be a right to appeal a Regulation 13 determination based on Regulation 9. Up to a point. Paragraph 6 of what says, given the only basis for altering and withdrawing Regulation 13 determination is in response to a valid appeal, well, as I want to say about judicial review, that's obviously another possibility. It's possible to make a valid appeal against a Regulation 13 determination in reliance on Regulation 9. Now, in paragraph 65, my learned friend says that if Regulation 9 direction has already been made, then yes, you must be able to appeal against Regulation 13 determination by reference to that, and that's plainly correct. The Commissioner is willing to go a little bit further and say that if a Regulation 9 refusal has been refused, and a Regulation 13 determination is then made, then yes, the appeal against the refusal can take an appeal against the Regulation 13 determination, and it's all dealt with then. But my friend goes much further than that. In paragraph 67, it says, if a Regulation 9 direction has not been made, then contractor must be able to appeal on the basis that one will be made. Now, on the face of it, that's not confined to the case in which Regulation 9 has been raised or refused. That would extend to a case in which the first time HMRC hear of any Regulation 9 issues is a notice of appeal to the first-tier tribunal. My submission is that it's too late to raise those issues then. It's too late to raise them once the Regulation 13 determination is made. And that's because of Regulation 13.3. I think that's all I want to say about point 7. Then point 8, the appellant's interpretation isn't artificial or subversive, and Regulation 9 doesn't always have priority. I'm not sure there's anything to add about that beyond the points I've made already. In my submission, ultimately, the second half of Regulation 13.3 must have some content. Its purpose is finality. If it's certainly an available reading that if no Regulation 9 issues have been raised, HMRC get finality by issuing a determination. One must recall, of course, otherwise then there is no time limit specified for raising Regulation 9 issues.
But the point was made earlier that the natural time limit is the Reg 13 determination becoming final.
Well,
I don't think it's been suggested that there would be any point in anyone trying to engage Regulation 9 after the Regulation 13 determination has in fact become final.
No, certainly it is common ground that
Okay.
once it becomes final, yes, there is no Regulation 9. The question is in between.
No, I just wanted to clarify
yep.
that was common ground.
Yep. But Justice Malone and Friend says that, on the one hand, that HMRC, in his submission that's not accepted, could thwart an appeal against a Regulation 9 refusal between this court's hearing of the appeal and this court's decision being issued by issuing a Regulation 13 determination. On Malone and Friend's view, the opposite is likewise true for in his position, because supposing you've got a Regulation 13 appeal, suppose the appeal is on the grounds of some of it was about materials or whatever, and this court hears the appeal, and tomorrow, for the first time, Regulation 9 issues are raised. There's no time limit against doing that. One of our friends' position says that's perfectly all right, and we've all been wasting years of our lives on some.
But wouldn't the court be, if a Regulation 13 appeal in that context was before the court, this court would be determining it on the issues before it?
Yes, exactly.
If it then
exactly.
upheld it, I mean.
But what my learned friend's position, as I understand it, as I understand my learned friend says, Regulation 13.3, the second half of it operates to prevent a Regulation 9 direction only when a Regulation 13 determination is finally determined. And that means if a Regulation 13 determination is appealed up to this court, final determination is when this court issues its decision and there is no further appeal. Because either time to apply for permission is refused or permission is refused or whatever. So in my friend's case, this court could hear an appeal against Regulation 13 determination on, for example, the grounds that the payment part of the payment related to materials. This court hears that. And then in between the hearing and the decision, for the first time, the recipient says, by the way, we forgot to mention condition A, and we should, and the Regulation 13 determination has to fall because of that. Now, that's obviously very unlikely, that scenario. But the point is, if my other friend puts up absurd scenarios, I could equally put up absurd scenarios in response. And test his theory to its very limits, that it is only on final determination of a Regulation 13 determination that is a cut-off point for raising Regulation 9 issues. The point being that these types of outlying situations, as one reads in various cases, clever counsel can think up all sorts of absurd situations to support one side or another. In my submission, though, a much more straightforward, simple approach can be taken to Regulation 13.3. It gives finality to the taxpayer when a Regulation 9 direction is granted, on the one hand, and to HMRC, where a Regulation 13 determination is made when no Regulation 9 issues have been raised. Unless there can be further assistance, I would invite the court to refuse the appeal.
As far as I'm concerned, no, thank you very much.
Obliged.
Anything by way of reply?
I'll be as quick as I can. My first observation goes right back to the beginning of my learned friends, or near the beginning, where he commented on the correspondence that HMRC, when saying they wouldn't consider Regulation 9.4, were responding to a request for Regulation 9.5. It's not really relevant to this appeal, but HMRC never suggested that we could do access Regulation 9.4 in any other way. So that's the only basis on which we thought we could ask for it. In relation to my learned friend's point about 3 million expenditure, I mean, the court's already got the point that it's not limited to 3 million. And in any event, even within that 3 million, you may have appeals or potential appeals that raise relatively small amounts. So it doesn't help anyone to focus on that amount. Then we come to the more substantive points. So my learned friend sought to explain the difference in wording by a proposition that the amount is external to a direction, but not external to a determination. I struggle to understand that, and I think in my submission it contradicts what both provisions say, because both provisions have, as their subject matter, an amount, and that is the amount that ought to be deducted. So it might be worth just looking at this point. I know you've seen this many times, but if we go please to tab 2, Regulation 9, paragraph 2. Sorry, if we start at paragraph 5. So HMRC may direct the contractor is not liable to pay the excess. What is the excess? That's in Regulation 9.2. That's the amount by which the deductible amount exceeds the amount actually deducted. But then if we go to Regulation 13, we see in 1B, HMRC has reason to believe that there may be an amount payable for a tax year that's not being paid to them. So they're both operating by reference to an amount. I cannot see how you can say one's external and one's internal. I've never heard that description before, but it doesn't seem to fit here. In terms of finality, this goes to the point my learned friend was making at the very end there. Bringing the Regulation 9 issue into the Regulation 13 appeal would depend upon the ordinary rules relating to amending grounds of appeal. I mean, that's a complete answer to what we were hearing at the end there. Trying to raise that as an issue for the first time in this court would receive the short shrift such points normally receive if they involve questions of fact that haven't been determined below. So, my submission, that goes nowhere. You have to raise it in proper time so that it can be determined as an issue in the appeal. Furthermore, also on finality, my learned friend's interpretation doesn't even bring him the finality he seeks. Because he accepts now that, well, even if we do issue a Regulation 13, that isn't the end of the matter, because you can appeal it. He has a limited, well, he limits the number of circumstances in which you can appeal it to circumstances where the Regulation 9 request was made before, and I think appealed before the Regulation 13 is issued. But nevertheless,
it's made and
I think his circumstances where you can appeal, continue your Regulation 9 appeal, is where the request was made and appealed and notified to the tribunal prior to the Regulation 13. He says, well, there the FTT is not deprived of jurisdiction. I'll come on to that. But the point
I wasn't quite sure whether he was saying that Regulation 13 takes priority if the Regulation 13 determination is made during a period in which the taxpayer could, but has not yet appealed against the refusal.
Yeah.
And where the taxpayer has initiated the appeal by notifying HMRC but hasn't yet gone to the tribunal. I'm not quite sure that I understood exactly what HMRC's position was on the intermediate periods.
Yes.
Although I did understand Mr. Simpson to say that once the appeal had reached the FTT,
yes,
a Regulation 13 determination made after that would not deprive the FTT of jurisdiction.
Yes. I have broadly the same understanding, my lord. And what that means is that at least for Regulation 13 determinations that HMRC issued before the appeal is notified to the tribunal, it is not the end of the matter, it is not final. And therefore that undermines Mr. Simpson's simple approach, or what he says is a simple approach, is saying, well, it's finality either way. No, even on your approach, Mr. Simpson, the Regulation 13 is not the end of the road, it's not final, in respect of Regulation 9 issues, in the circumstances he describes, whatever they may be. And there's, I agree, there's an ambiguity there as to what happens when you appeal to HMRC but not the tribunal. But that's just to show that the finality Mr. Simpson seeks doesn't really arise even on his analysis. My next point is that there is a situation Mr. Simpson doesn't deal with, which is where HMRC aren't able to issue a warning letter before they act, because maybe their time limit is about to expire and they need to protect the revenue. In that situation, there will be no prior request for Regulation 9, and this is in fact envisaged by HMRC's own manuals. So in the authorities bundle, tab 18, page 534, and on the second paragraph of 534, it states, if you believe that there is likely to be a loss of tax to the Crown, then you must immediately issue immediate Regulation 13(2) determinations. So that's in distinction from the usual practice of giving an opportunity or giving a warning. And so there will be situations where HMRC feel, well, we have to. Here's the Regulation 13. And in that situation, the possibilities Mr. Simpson was discussing, complicated as they are, don't even arise on his submission. So he hasn't solved all the problems, even with his complicated system. But then we turn to look at that complicated system. And Mr. Simpson says, well...
So, I'm not sure that last point is strictly within the proper bounds of response. Because that point has simply not arisen at all before.
Well, if you need to respond to it,
it's not a point arising
from the chance afterwards.
So we then turn to the complicated system. And Mr. Simpson's first point is, well, you can judicially review a Regulation 13 determination that was issued to protect the revenue, in some way relying on Regulation 9, and his submission as to what that ground was error of law. But I can't honestly see what the point of law would be. Error of law means what it says, that you've got the law wrong in some way. Condition A is an evaluative conclusion as to whether you took reasonable care and had a genuine belief. Reasonable views can differ on whether reasonable care was taken. And if HMRC take a different view to the view eventually taken by the tribunal, that doesn't mean HMRC erred in law, it just means that the tribunal's taken a different view in an evaluative way. So the ground of review doesn't exist, and Mr. Simpson wasn't able to suggest any other ground of review.
And if you look at the grounds of appeal under Regulation 9, they are the matters of which HMRC must be satisfied.
Yes.
But they don't include, so to speak, the satisfaction itself.
No.
In other words, the FTT is itself a fact-finding body.
Yes.
On what needs to
yes.
be shown.
I mean,
it's not reviewing the decision of the officer who said he wasn't satisfied.
No, it's not supervisory. It is full appellate on those specific questions, my lord. And so the tribunal could end up saying, well, look, you HMRC weren't satisfied, that's fine, but we've taken a different view, having heard the evidence and the explanation of the taxpayer, and we issue our direction for you to make a direction. That doesn't involve saying HMRC made an error of law. They may have reasonably reached the opposite conclusion. But this is a situation where there's full appellate jurisdiction. So the point is there's no ground of review there. So you can't judicially review it. And then my learned friend said, well, and also you can appeal the Regulation 13 on the ground that Regulation 9 ought to be made, or ought to have been made prior to the Regulation 13 being issued. But that takes us back into the problems I was raising during my submissions, which is, does that mean that the Regulation 13 appeal, following that logic through, will have to consider and decide whether a Regulation 9 ought to have been issued? And if so, and this is a point Mr. Simpson didn't address, that would logically be on both bases, Condition A and Condition B. So Mr. Simpson is saying a valid ground of appeal against the Regulation 13 is a Regulation 9 ought to have been made. Let's assume the taxpayer did request to rely on Condition B before it was issued. HMRC said no. They issued the Regulation 13. It is appealed on the ground Mr. Simpson suggests. That is the matter that then the tribunal has to determine. And perhaps it's useful just to look at how the appeal legislation does work. Because Mr. Simpson seemed to think that, well, you can appeal to HMRC on grounds that you wouldn't put before the tribunal. There was at least a hint of that, because he seemed a bit uncomfortable about the idea of the same point going to the tribunal. But if we just look, please, in the Taxes Management Act, it's section 49A is where it begins. And this is set out in my supplemental skeleton, so these are not points, and this is why it's in the bundle. It's on page 77. This section applies if notice of appeal has been given to HMRC. And in such a case, the appellant may notify HMRC. HMRC may notify the appellant of an offer of a review. The appellant may notify the appeal to the tribunal. So you don't have to go through the review mechanism. At 49B, if you require a review, HMRC must notify the appellant of HMRC's view of the matter in question. It's that matter in question that forms the thread throughout all this appeal procedure legislation. And you see in 3, HMRC must review the matter in question. Skipping over to 49D, please, on page 81. This section applies if a notice of appeal has been given to HMRC. You may notify the appeal to the tribunal. If you do, the tribunal is to decide the matter in question. And the same point is repeated elsewhere, because there's a few different ways you can end up at the tribunal. But just to finish off that point, the matter in question is defined in 49I. That's on page 91. It means the matter, so 49I, subsection 1, matter in question means the matter to which an appeal relates. And so when you follow this through, you appeal to HMRC on a ground, that becomes the matter in question. You then, that then is what they can review, and that is then what the tribunal has to determine. So Mr. Simpson is saying that the matter in question can be that you ought to have issued a Regulation 9. That is then the thing that HMRC can review and express a view on the matter of, but equally, the thing that the tribunal has to determine, which ends up saying that the tribunal can determine whether Condition B was met on a Regulation 13 appeal, which, well, I've already made my submissions on that. In terms of then Mr. Simpson's argument, and this seems to be a new fundamental point that he relies on, there's no authority for it, but Mr. Simpson says, well, once the jurisdiction exists in the first place, at the time of making the appeal, it can't be ousted. But he doesn't explain any authority, refer to any authority for that, or explain it. It just seems to be assertion. And it falls into a big problem at the practical end. And this is the point I think my lady Justice Falk picked up, which is that the jurisdiction under Regulation 9 is a jurisdiction to do a thing if a condition is satisfied. And the tribunal only has jurisdiction to do things within its jurisdiction. So the thing within its jurisdiction here is either to direct HMRC to issue a direction or not to do that. The grounds on which they can do it is the Condition A grounds. Nevertheless, the only thing they can do is decide to do or not do that thing. There's a contrast between Regulation 9.9 and Regulation 13.6, which was referred to earlier. Because there, the tribunal does have jurisdiction simply to decide the answer to a question. And so what Mr. Simpson ends up saying is that the tribunal has no jurisdiction to do the only thing it had jurisdiction to do in the first place, which means its jurisdiction has been ousted. The idea that it can decide a point that would have been relevant if it could have exercised its power under Regulation 9, Paragraph 9, is neither here nor there. I think I was at 2 points left.
I mean, might that problem be solved by a bit of case management, by ordering a preliminary issue? Or would you say that there's no point in ordering a preliminary issue if it can't lead anywhere?
It's not even a preliminary issue, is it? It's the only issue. And I would have to look at the tribunal rules, but I'd be fairly confident in saying that it's not a preliminary issue if it's, as matters stand, academic, because the tribunal has no jurisdiction to do anything based on it. And it's not preliminary in any ordinary sense. It's the only thing that the tribunal would ever have to decide. The two final points were, first, in terms of North Point, well, the High Court clearly understood it in the way that was suggested by my Lord Justice Lewison, because if we read the end of paragraph 21, and this is tab 7, page 95, but I'll read it out. It says, in a nutshell, what North Point decided was this: a liability determination precluded the success of an extant carefulness basis appeal, which would have failed anyway, brought against a prior refusal to make a non-liability direction, because it precluded the coming into being of even an FTT-directed non-liability direction, which alone could excuse on the carefulness basis liability to pay. So that was the High Court decision. And it's now Mr. Simpson seeks to draw a distinction, the very nuanced distinction between, well, it's not quite clear where the distinction is drawn, but between, I think he says you have to ask for it before.
Well, I think it possibly goes as far as saying refusal before, because the assumption is that if the revenue have engaged with Regulation 9, they'll have reached a decision on it before deciding to issue Reg 13. It leaves to one side your point about what if you're at the last minute.
Yes.
But I, for my part, understood the confirmation that North Point would not be supported.
Yes.
There's meaning that this revised approach would apply in that situation.
Yes. Well, I mean, we did hear that North Point is accepted not to be correct on this jurisdiction point, which just throws it up into the air as to what the law is and how we reach there. And this is my final point, is there's no basis for this distinction in the legislation. As carefully crafted as this complicated structure might be, and even if the remedies in terms of judicial review and grounds of appeal against the Regulation 13 existed, we just don't get this distinction from Regulation 13.3. It does not say that you can continue challenging a Regulation 13 on the grounds of a Regulation 9 in certain circumstances, not in others. And this goes back to the 3 points I made this morning as my fourth preliminary point. In particular, this question is binary. Either Regulation 13.3 does preclude a Regulation 9 after it's been issued, or it doesn't. I don't want to repeat myself, so unless I can assist the court any further, those are my submissions in reply.
Okay, thank you. Mr. Simpson, I'm afraid I didn't make a note of what was the point of which you thought was a viewpoint. Do you, on reflection, wish to address us on it?
The point was that I had not said anything about situations in which no warning letter had been given, and it was made by reference to the
manual.
which is that.
Well, I think the question of warning was discussed during your submissions.
Yes,
So it's
I
not
did.
something that you stressed. You stressed that the taxpayer here had been warned.
Yes, although that
Mr. Simpson, all Mr. Firth was saying was that there are circumstances when the taxpayer won't have been warned.
yeah, so as my Lord the Chair said, that was more an advocacy point that isn't relevant to the interpretation. And if one looks at the circumstances in which no warning letter is given, they are where a recipient is about to dispose of assets, flee the country.
There's nothing in the regulations which requires a warning to be given.
Indeed.
It's simply HMRC practice. I assume that the manual is a publicly available document, so it's a published practice.
Yes.
So somebody who wants to understand how HMRC operate the scheme will know that normally a warning is given, but that sometimes it isn't.
Yes, and the warning is a boon to taxpayers, or addressees rather. But yes, sometimes it is, but in certain circumstances, like fleeing the country,
We've got the point.
That's all. I'm obliged more.
Very well, thank you. We will be reserving our decision. Judgments will be circulated in draft in the usual way, so that the parties can agree the terms of the consequential order, or if they can't, submit brief written submissions on the basis of which we can determine the outstanding points at the time of hand down. Also, of course, for the purpose of correcting any typographical or other minor factual errors, those are the only purposes for which those are broadly the only purposes for which the judgments are circulated, and that affects obviously who can see them while they remain in draft. If you want any further guidance on that, you can find it in the Counsel General for Wales case. Thank you both very much.